elections. The two principles had differed, and that is where the political alignment and formations came about. Are we likely to see the same thing?
Oh yes, we will see a lot of political realignment. Number one, if
just a minute, Doc. Those are live pictures from the Milimani locals, and as you can see, the impeached Deputy President Rigathi Gachagua is seated in the company. I can spot 2 or 3 lawyers there, and the court is quite full. We'll be crossing over to Milimani locals any moment now, as soon as this petition begins. But currently, we are here in studio and waiting for for the judges at the Milimani locals.
Thank you so much. I can see Riggy is now well, and I wish him all the best. And number two, there'll be a lot of realignment. If Riggy will be sent home, number one, he will form his own party, and he will canvanize the Kikuyu vote in totality.
That is if the courts clear him, because if they don't clear him, that it is not viable to vie for any political
In any case, he will form his political party.
Either way.
Either way. Number two, William Ruto will go to Nyanza and Western, and then Mount Kenya East, that is the Meru, and the Rift Valley, that is the Kalenjin votes, and Coast. And if Raila loses the AU post, it will be messy and noisy. Because Raila will feel shortchanged. And Raila, to me, that is a person that you cannot trust in politics. To me. I don't know, to Meli. Raila can jump, and even he can go to Rigathi side in the next election. And that is the real politician. He is a real survivor in this country. And he has survived all through. And he knows how to do that. So, Rigathi right now, where he is, but if he is not impeached, he will silently form his own party, and his constituency will not trust again William Ruto. Take it to the bank. Either way, he will not trust.
Still on the same, Doc. As we have said, is that what we don't hear and what we don't see is where the politics truly lie.
It is true.
And I remember him in one of the televised interviews, he said that because he was so trusting, Mount Kenya as a region or as a voting bloc did not come on the table with an agreement or conditions or anything, whereas we see the likes of Speaker of the National Assembly, Dr. Moses Masika Wetangula. We've seen the likes of the Prime Cabinet Secretary, Musalia Mudavadi. We've seen the likes of PAR leader, who is the Speaker of the Senate. From what the DP said, and from the documents that he presented to court, is that these people had an agreement, including Mutua of the Maendeleo Chap, which actually sponsored the bill, the impeachment motion. Was it the undoing of the Mount Kenya region to not enter into that agreement in a political outfit? Remember, during the TNA, Uhuru had TNA, and the president, who was the deputy president back then, had URP.
It is true.
Was it the Mount Kenya region undoing?
To me, it was not undoing, because you remember during 2022, we had another party in Mount Kenya. That is for Uhuru Kenyatta, Jubilee Party.
And you also had the likes of Kionjuri.
Yes, you can see. And even Moses Kuria. And even Waria. Okay? And even Kabogo. So Rigathi saw that if I have another party, it will not have a lot of effect. So he joined hands with Ruto in the fate of Jubilee, the Jubilee of 2017. Okay? But he didn't foresee this thing coming. He didn't see that this is coming because of the faith. The Christian faith. You know faith. You don't reason. Okay? You just trust in God, that there is God in heaven. You don't reason. So Gachagua with Pastor Dorcas trusted Rachel and Ruto, the Christian faith, and say we are going to this war. And at the end of it, we will reach the mountain, and eventually we will be in heaven. But now look at this. He didn't foresee this. But going forward, he will form his own political party. Mm-hmm. And by the way, right now, Rigiji ako juu sana. Mm-hmm. Right now, where he is right now. In fact, let me tell you, if election comes in November, him and Ruto, mm-hmm. he will beat Ruto. Right now. That is my analysis.
Meli, let's go back to the truthful man again. He said there is a truthful man, and on Sunday he mentioned that some of the reason that they were at loggerheads with his boss is because he brought about Adani, he brought about the affordable housing, which is also being challenged in court. But let's go to the truthfulness and honesty. When he was deputy president, Rigathi Gachagua did drum up support for the affordable housing, only now to come and castigate it. He talked about tapping in foreign investors, Adani being one of them. He's bringing up all those issues now. Is he really being truthful and honest?
Now, one thing, what I was thinking about all this scenario that we are seeing, there is too much going on in this country, and perhaps this is a decoy. The Rigathi issue could be a decoy that is diverting our attention from the Adani issues, diverting our attention from Shif and Shah. I heard somebody calling it Shisha. They are diverting our attention to the housing, from the housing issues that we had, and perhaps this will take some time, some sweet time of our attention, such that at the end of the day, things would have moved under the carpet. But the truthful man branded himself. He used to say things, and we believe him. Even up to the other day, when he was speaking, he came through a press conference before he appeared in the National Assembly. He said quite a number of things that, quote unquote, ended up putting him in trouble. And I said before, always say less than is necessary. By being truthful, he was trying to win the hearts of Kenyans more than his boss was doing. And perhaps he was trying to outshine the master, and the master realized in good time that this guy, if I'm not careful, will take over my government. The truth we have, but when you hear what was happening in the National Assembly, some were truths and some were half-truths and some were exceedingly outright lies. And therefore, his truthfulness is still in question, but he had won their hearts. The crying of the deputy president's wife, Madam Pastor Dorcas Rigathi, crying before the camera, whipped our emotions. Even those who had hard hearts changed, because nobody has ever seen anywhere above the ruling class crying. And that is when I learned one thing: the rich also cry. The only cries I saw that were from that class is when President William Ruto did not believe that he was the deputy president. He couldn't believe that he would be sitting on a deputy president's chair in a place he used to go and book appointment. That was the last cry I saw. So this crying whipped our emotions. It has brought back sense to some of us who had very hard hearts and were unforgiving. But all this was I could see things like this coming from regarding these speeches all through. Sometimes even somebody would ask, why did he have to say that before the president? In fact, even guiding the president before the multitude. And you would see, if you see William doing this and smiling, my friend, you have hurt his heart. He is not smiling. And these things were planned, they were there, and he knew that it was coming. That is why he was even more bold towards the impeachment season. He was bolder and even courageous to handle some issues. The issue of Gen Z, when he addressed us in Mombasa, one thing was, why was he addressing us from Mombasa when the president was addressing us from State House, Nairobi? It reminded me of a movie, The Designated Survivor. He was playing the designated survivor, that in case things happen here, I take over from Mombasa. And perhaps that also anchored his boss. And you know, for those people who are close to William Ruto, will tell you that once William Ruto starts ignoring you, know that he never tells you that he has a problem with you. He just starts ignoring you. Know that you are in his wrong books. And if we are not careful, we'll go back to my first statement. This is a decoy. Something is going on in this country. Once we wake up, we will have Adani International Airport. Kenya Power will be Adani Power and Lighting Company Limited, because there are some things perhaps Rigathi was against. At the end of the day, why would you sell our heritage? Why would you privatize our heritage?
For 30 years.
For 30 years. Hata ingekuwa 10 years. At 5. Actually, by 2032, if he's living, we would have somebody else to take over from that. But giving somebody, imagine Troy, at this time, let me assume you are 39. In 30 years, you will be 69.
Actually, in the next 30 years, I'll be in my 40s. In my 70s.
Yeah, you'll be actually 70. Tokona sign in pesa ya wazee. 30 years is a lot of time to give out a national heritage like that.
All right. Since somebody can argue that that has not been put into pen and paper yet, I will still pose the same question I posed to Doc in regards to how do you see the political formations coming up. But before you answer that, allow me to remind our viewers that those are live pictures from the Milimani Law Courts, and as I can see, the court is quite full. We're expecting the petitions in regards to the impeachment of impeached Deputy President Rigathi Gachagua will be heard by a 3-judge bench. I can see the likes of lawyers Kibe Mungai, I can see lawyer Ndegwa Njiru, I can see the former UDA SecGen Cleophas Malala, I can see the brilliant lawyer Ongoya, we can even see the Kiambu woman representative, the likes of lawyer Danstan Omari, I can see also Ndegwa Njiru, also a brilliant lawyer, and also some politicians here and there. I've seen the likes of Dan Manzo, who is a senator, and we are waiting for that case to be heard and determined. So as soon as the judges do get into that law court, we will be crossing over. So back to you, Meli. What do you think are the political ramifications of such a move in regards to the DP? We saw 2017, a lot of new alignments.
Now, we had a disclaimer from the word go. Musiguse Murema. And the truthful man was saying that. That mountain has been shaken. That mountain, the volcano and the magma that is bubbling in that mountain, I don't know what we will need an atomic bomb to take it back. First, things first. William should come out, President William Ruto should come out and unite the country. Assure us that the processes going on are constitutional processes, calm down the country, and at the end of the day, I don't know what he will have to do to bring back the mountain that he was told not to touch. That mountain is slowly shifting, seismic activity down on the tectonic plates of the mountain are actually rumbling and shifting. We might have a serious rift that he will have to build a serious bridge to go back to the mountain. Otherwise, if that doesn't happen, or if this happens and Rigathi goes home, the mountain has gone home with him. The mountain will be looking at Rigathi to give it direction. Where next? What President William Ruto should do right now, if that happens, put all his resources, human and supernatural, on the presidents of Africa to vote in Honorable Raila Odinga to be the AU chairman. Then he will bring the lake, which he will use the water of the lake to calm the mountain. Otherwise, this mountain, the volcanic eruption that is there, has never been had in the history of this world. These people are united. I have never seen a people united like the people of the mountain.
All right. And still on the same, let's be very honest. Since the finance bill, the ground has been hostile.
Yeah.
True or false?
True.
In either way, whether the DP was impeached or not, the ground was still hostile because of the finance bill. And of course, a number of Kenyans have mentioned, you told us there's a hustler government, you told us Mama Boga, you told us there's that hostility on the ground. And they say vitu kwa ground is different. Now, this is something else that has come, of which, like you said, the tectonic plates are rumbling. Where does this leave Kenyans as well? We also have to remember that Kenyans were not quite happy.
Now, the Kenyans should understand one thing, is that mwanasiasa si mwenzako. A politician is not your fellow, your peer, because these people can unite on issues that are bedeviling them and ignore you. Let's not whip our emotions and follow the politicians' directions. We should be sober. Remember that this country is one united country called Kenya. We are Kenyans. Since President William Ruto took over, not even a single plate increased in my home. The size of ugali that we cook is still the same. The sugar that we put in our tea has always remained 2 spoonfuls per cup. It has never changed. And that is why what we should and look at is not where the president comes from. Because Bwana Kosgei here can tell you, Daktari, that where he comes from, in fact, perhaps the roads are even worse than they were before. What I am looking forward to is even having a Giriama president, a Ribef president, a Somali president, a Taita president, a Luya president, but somebody who works. We should look forward to a day when Kenyans will have clear objectives on their election of who to rule them or who will lead them. Otherwise, Kenya is a unified country. We should not whip emotions into what is affecting politicians, because at the end of the day, when you sleep angry, he doesn't send you tea, he doesn't send you soap to wash your clothes, but what we want from politicians is to give us development. I want, when I leave my home, I have a good road, I have affordable fuel, I can live securely. I don't need security. Because what even the deputy president, impeached deputy president, was trying to send a message is, we are insecure in this country. That is why he needed security. From who? From us. He feared us. He fears us. That is why he cries for security. And I'm wondering, look at when the president was in the US, he was crossing the streets. I could see him crossing the streets of New York. There's even a small girl who bumped into him and he pushed her aside. Even the security were not there. I'm looking forward to a day we shop here at Quickmart with the president. Namuona anashika nini na mimi niko na yangu.
And the governors wakipanda basi,
and the
just like they do in Europe.
Buses.
Yeah. And since from what I've seen is that the court is almost in session. Let's go back to something you mentioned, and it's something that has come up not only this year. some people have claimed that Parliament is an extension of the executive. Let's look at the MPs.
Yeah.
After the finance bill, Kenyans were very hostile, and actually some were chased away, and some had to wear T-shirts saying, "Forgive us." But let's be very honest. The leaders that we have is a true reflection of who we are. You remember the finance bill? Yeah. They voted yes, despite Kenyans saying no. Yeah. And then the president comes out, flanked by the MPs, and said that, indeed, that's it. We're not going to go on with the finance bill. How do we ensure that Parliament is not an extension of the executive? But unfortunately, my director, Mugo Kariuki, said, tells me that, informs me that we have to go to Milimani Law Courts. Sami Meli, a governance expert, just next to him. We have Dr. Benjamin Koskei, lecturer at the Kenyatta University, and also a political analyst. Thank you so much, Injil, for joining us. Let's cross over to Milimani Law Courts and follow up on the DP, impeached DP petition.
I'm Dorcas Odura, Attorney General, Senior Counsel. The Attorney General has also been sued as a party, and therefore representing the Attorney General is Professor Githu Muigai, Senior Counsel. Shadrach Mose, the Solicitor General. Emmanuel Bita, Deputy Chief State Counsel.
Emmanuel who?
Emmanuel Bita.
Where is he?
I'm present, Mercy.
He's been swamped. And Charles Mutinda, Deputy State Counsel.
Present, my Lord. Present.
For the National Assembly, we have Eric Gumbo.
I'm present, my Lord.
Paul Nyamodi.
Present, my Lord.
And George Murugara.
Present, my Lord.
For the Speaker of the National Assembly, we have Benson Milimo.
Before you, my Lord.
Josephat
Just
Kuyoni.
too fast.
Oh, sorry?
We introduced Mr. Murugara for.
Mr. Murugara George for National Assembly. For the Speaker of the National Assembly, we have Benson Milimo.
Present, my Lord.
Josephat Kuyoni.
My Lord, I'm present.
Josephat who?
Kuyoni. Kuyioni. For the Senate, we have Professor Ojenda Tom, Senior Counsel.
Present.
Moni Mukele Edwin.
I'm present, my Lord.
And Senator Hilary Sigei.
I am present, my Lord.
Moni who?
Moni Mukele Edwin.
And Professor?
And Senator Hilary Sigei. That is for the Senate. For the Speaker of the Senate, we have Mercy Panji. And Peter Wanyama.
I'm present, my Lord.
For Professor Kindiki, yes, and DP nominee, we have Mudomi Fiankolu.
I'm present, my Lord.
Moses Kosgei, and Ken Meli.
Present.
My Lords, your leadership, in petition 565 of 2024, may I, at the very outset, before I state counsel appearing as the Deputy President applicant, may I, at the very outset, say that I am stating the quorum under protest we are not willingly here participating, and we will elaborate. But let the record show that counsel appearing for the Deputy President today before this honorable court appear at a protest. As I say, the basis will be elaborated later. I appear, I'm waiting for the record, I appear with my colleagues, Tom Acharya, Elisha Ongoya, Faith Waigua, Victor Soanya, Debo Wanjiru, Andrew Muge.
This we are recording the program. Faith Waigua,
Victor Soanya Ogeto, Debo Wanjiru, Andrew Muge, George Wandati, Mr. Sakin Pa, and John Job.
President Lord.
My Lords, Your Ladyship, as I sit down, I seek clarity on whether it is only petition 565 of 2024 that this honorable court has before it today, or whether there are any other petition. I thank you.
So we'll take quorum on all the files that are before the court first.
Petition E015 of 2024 at Kerugoya. Petitioner David Muni Mazenge and 4 others versus the National Assembly and 5 others.
May it please your lordships and my lady judge, in E015 of 2024, the quorum for the response is the same, save for His Excellency the President, who has been sued in person and is being represented by Adrian Kamodo.
Just for the purposes of clarity, just we'll record the quorum fully.
Dorcas Odur appears the Attorney General. For the Attorney General is Professor Igai, Senior Counsel, Shadrach Mose, Solicitor General, Emmanuel Bita, Deputy Chief State Counsel, and Charles Mutinda, Deputy Chief State Counsel. For His Excellency the President, Adrian Kamodo. For Professor Kindiki, is an interest, yes. Mudomi Piankolu, Moses Kipkogei, and Ken Mele.
Your Lordships and Your Lordship, my name is Kibe Mungai, appearing in this matter with the following. My Lord, in this matter, I appear with Senator Daniel Manzo.
Present, my lord.
Your name, please. My name is Kibe Mungai. I thought I'd said it, my lord. Kibe Mungai. Sorry about that. I appear in this matter, my lord, with Senator
continue behaving like this, I won't go back in the car.
All right, if you don't get in, how will you leave? See you later.
Iker! No, Iker! Live in my house. I won't allow you to get me into more trouble than I have.
This is also my house, right?
How many times will you favor him over me? What else do I have to do for me to be chosen?
I thought that Sergio was going to ask me to marry him. And he didn't say anything, no, nothing at all.
And the 2 times she was with Danielle, they ended up in the hospital.
What did you say, Mother?
Arturo! What's wrong? What is the matter?
Wild lands.
That continues to be referred as Kerugoya, petition number E015 of 2024 that appeared to have been filed on the same day
So you appear for which party?
We appear for the petitioners in that matter.
Here for the first interested party, that is the Deputy President of the Republic of Kenya in this E015. The Lord, again, let the record capture and show the council appearing for the first interested party appear under protest. Council are as follows. Paul Mwite, Tom Acharia, Elisha Ogoya, Faith Waigwa, Victor Soanya, George Wadati, and John.
Can we have that again?
Yes, I'm sorry. From what point, my lord?
From yourself.
Paul Mwite, Tom Macharia, Elisha Ongoya, Faith Waigwa, Victor Soanya Ogeto, George Wandati, and John Job. At the appropriate time, we will be going into the grounds and bases for appearing under protest. I thank you.
My Lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given. My Lord,
before Mr. Kibe moves on that file, there are other files, especially file number petition E572 2024. Is it before the bench?
We'll take quorums on the files which are before the court and that you can raise any issue.
My lords, may you kindly equally confirm whether E509, which was consolidated with E522, is before the bench. One reason, Your Lordship, is that the bench was specifically constituted for that purpose.
Petition E13 of 2024, High Court of Kerugoya, Thomas Kimozo Maingi, petitioner versus Deputy President of Kenya, respondent, and Honorable E.G.
My Lord, that matter is not before the court.
Your Lordship is being called. It is the court that should know whether it is before the court. We also want to know whether it is before this court.
My lords and my ladies, kindly, with your kind permission, I would also want to seek clarification for my own petition which I have filed, petition number E567. I had information that that file was also coming up before you this morning, and I would like to know whether the same is before you and if so, whether we can also proceed with it.
When was it filed?
It was filed on the 18th of October 2024, and it came up before Honorable Justice Mwamuye, who gave directions that it should come up actually tomorrow. And I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today. So I also need clarification.
May it please the court. My name is Dr. Eboso. I'm a petitioner in E541 of 2024, a petition that was filed on 8th of October, and a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench. It raises the same issues as the issues that were consolidated, and I'm appearing in person with Ms. Ivy Mwangi, the second petitioner, and we were seeking clarifications with regard to directions on that file, because as we can see, there are files that were filed on 17th of October, and which directions were given, and the bench was constituted. So we expected that the matter would be mentioned together with this one today. Thank you.
Lord, with utmost respect, this honorable court is a court of record. And the record is very, very important. My Lord, Your Ladyship, we heard the court assistant call out petition E13 of 2024, and she mentioned the word order. That is the file that was called out. And in order for the record of this code to be systematically accurate and easy to follow, may I, with respect, ask that we get clarity on this file that was called out, E13/24 of Kiloboya, before we go to the other matters. And perhaps it is for this honorable court to clarify which files, one by one, are before this honorable court. This
Senior Counsel Paul Ngute, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us also to talk. So I've heard you.
Thank you.
For this morning, for the purposes of hearing this morning, the applications which are before the court are application number E0113, which was consolidated in Kerugoya before it arrived here with E0114. 0114. Then we have application number E0115, also from Kerugoya. That is application before this court. And then we gave direction on those applications. And then E565. Those are the three matters which are before this court and in which the Honorable the Chief Justice has constituted this bench for hearing and determination. There are articles of constitution of this bench in the court. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given directions pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them. Maybe they are yet to reach us, but for the purposes of today's hearing, we have these 3 petitions or applications.
Your Lordship, we well guided. And perhaps also to state for record that we also appear in E015 in protest. But further that, Your Lordship, kindly confirm that the number that is now registered in the matter that came from Kerugoya is E015. And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at Kerugoya, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we raised the issues? Just confirm on the question of the integration of that file with the Nairobi files, because the last file that we have should be 565 as at Friday. Are we dealing with the matter in Kerugoya or in Nairobi?
Let me deal with that. Lord, for the purpose of E572 of 2024.
That file is not before us.
That's all I'm only saying. I have heard the directions of the bench. The file is not before you. But I have instructions for the purpose of the work to take that petition was filed on 18th of October. The same day the Kerugoya file was filed. All the directions in all these files that have been taken to a graveyard is that none of these files of ours have orders. The reason as to why Kerugoya files before the learned judges is purely because they have orders to stop the swearing in of the deputy president-elect. The CJ could not have selectively decided to have only one file before you, my lords. This is a trial of the judiciary. It is a trial that goes to the root cause of whether there is impartiality.
Mr.
Yes, my lord.
Mr. Omari.
Yes, my lord.
The file you are addressing us, we have said, is not before us. And the files which are before this court are the files in which this specific bench has been empaneled.
Thank you, my lord. Allow me to mourn. Because the questions I'm raising are very pertinent, that there are files selectively brought before you, but there are others.
Mr. Omari, we wouldn't know that because, as you understand, we only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has heard me now done. Thank you.
And Lord, if you could mourn elsewhere.
My Lord, I had indicated to this honorable court that there will be at least 3 clarifications.
Just a minute to something.
Yes.
Now, I think we need to get some things right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted, on the basis of that order, to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that we are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why you are here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
My Lord,
just a minute, please.
Perhaps Justice, to add that the numerous other petitions that are coming up, I think the process is ongoing. Maybe not all the files have been transmitted to the bench. Maybe by the time we leave this courtroom, other files will have been transmitted to the bench. But as we speak now, here and now, these are the only files that were transmitted to the bench and in which there are applications where the bench gave directions for hearing today. That is not to say that those are all the petitions there are. We don't even know whether the transmission has been done yet and that we will go back and find all the other petitioners whose concerns are valid. Perhaps those files will now be before the bench for months.
Yes, my Lord, I believe now I can be able to make the clarifications. Starting with the immediate background that we need to make these clarifications, and we take into account.
Let us finish with quorum first.
I was assuming quorum was.
No, there's a quorum in E013, which was consolidated in Kerugoya with E014. Just take quorum on that file.
Your Lordship, is terribly something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, E13 was not part of what was called. I've not heard it. Perhaps it will be called. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
What are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated. Let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The directions from this court were very specific on 3 different files.
My Lords, I'm more guided, but when Justice Rima was giving the clarification, I never heard him clarify whether the Kerugoya file has been integrated into the Nairobi system? Because we cannot be dealing with a file that is reading Kerugoya. Because of course, if there is no integration, Your Lordship, then there is a rat that is made.
Let me answer you. You said that records speak for themselves. And for record, matters which came from Kerugoya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Kerugoya was already consolidated. Those proceedings which took place in Kerugoya consolidated these two files. So let that not be an issue here. On the directions issued on 11th by Judge Richard Mwongo, these were the directions. The petitioner in E014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to Honorable Chief Justice forthwith, the party's response to the amended petition and petition E013 of 2024 may be filed in Kerugoya under the Kerugoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Kerugoya. So this court has not consolidated any matter. Petition number E014 and petition number E013 are hereby consolidated. The parties who appeared before the Kerugoya court were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Kerugoya is this. Going by the orders which were issued by Kerugoya court, there was a specific order that because of the transmission, parties will still file their documents under the Kerugoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume we may now raise the issues that we want to raise, particularly arising from the issues in Kerugoya. And I do not
know. Then proceed and take forum on it. They were consolidated, so we will not take further forum on this matter.
The Attorney General, I don't know, I had indicated to the court earlier, I need to raise some clarifications.
Section 7 of the Attorney General's Act.
You had already asserted it to speak. It doesn't override my right to represent my clients.
I'm repeating.
Can she then say her piece? I say mine.
Which matter are we now dealing with?
We have 0115. We have 0115.
My Lord, I wanted to say that the only matters before this court are the matters which had expired orders. The matters that came from Kerugoya E13 and E14, although consolidated, they were filed before impeachment and they have no conservative orders. We have E15.
E15 has
conservative orders, but E13 and E14, although from Kerugoya, they were filed before impeachment and they had no conservative orders.
I hope I can then be heard without further interferences. My Lords,
So which is the matter, Mr. Kibe?
My Lord, I'm leading the number of advocates in this matter from Kirinyaga, E015.
Kerugoya 15?
Yes, Kerugoya 15.
Kerugoya 15, yes.
Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable the Chief Justice, which has been placed on record in an affidavit in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That letter is on record. We do not trust that the Honorable the Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordship, sir, that you are convened by the Honorable Lady Justice Mwini, the Deputy Chief Justice. Lady, my lords, arising from that are one, a legal issue and a matter of Article 150. My lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitutions. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
my Lord Mayor,
I think I have a right to raise those issues. I will have a right to respond.
Just give Philip Mungai time.
Mungai, Muigai.
I just want it for good order.
Okay. Is that a clarification, Mungai?
Muigai.
The case against them. The issues raised by the petitioners, and we were able to respond in detail and with particular particularity to each and every one of those issues. Therefore, We are of the view that roundly considered, the petitions meet their narrator Karimi threshold. We bear in mind that in Mumo Matemu versus Trusted Society, the Court of Appeal said that precision is not coterminous with exactitude. We've relied on a quotation from that particular decision. Accordingly, we find no merit at all in the respondent's contention that the petitions do not meet the requirement of specificity. Moreover, Rule 10.3 and 4 of the Mutunga rules state that the court may accept an oral application, a letter, or any other informal documentation which discloses denial, violation, infringement, or threat to a right or fundamental of freedom. An oral application, that's now 4, shall be reduced into writing by the court. As noted by Justice Muita, in addition to allegations of violations of rights under Article 22, the petitioners also alleged inconsistencies between certain provisions of the various provisions of the Act and the Constitution. And in this regard, Article 258 is explicit that every person has the right to institute court proceedings claiming that this Constitution has been contravened or is threatened with contravention. We have also quoted the other provisions of that particular article. So we are in full agreement with the position taken by Justice Muita in the ruling dated 3rd May, and we quote from paragraphs 50 to 54 that Article 165 confers this court with the jurisdiction to determine whether any law is inconsistent with or in contravention of the Constitution, the question whether anything said to be done under the authority of the Constitution is inconsistent with the Constitution. We've quoted those paragraphs. Now, in connection with the doctrine of avoidance, we referred to Communications Commission of Kenya, and we've quoted also from that decision that the principle of avoidance entails that a court will not determine a constitutional issue when the matter may properly be decided on another basis. The Supreme Court relied on a South African decision, and we've basically quoted from the decision of the Supreme Court, paragraphs 256 and 257. Similarly, we relied on KKB and SCM and others. The court had the following to say, and we quoted from it. In summation, the doctrines of ripeness and constitutional avoidance shun to deal with a constitutional issue where there exists another legal cause which can give the litigant the reliefs he seeks. In other words, a constitutional issue is the only cause that can give the litigant the remedy he seeks. Both constitutional avoidance and ripeness avert the determination of the constitutional issues until it becomes necessary, to the extent that it is the only cause available to assist the litigant's cause. End of quote. We also relied on Farage and the others versus Police and 2 others to support that doctrine. So then what was our conclusion? Having acknowledged that the predominant issue is whether the provisions of the Affordable Housing Act are in conflict with the Constitution, it is our considered view that that doctrine of avoidance is inapplicable to the petitions as consolidated. I'll invite my colleagues to consider the first, to read our judgment on the second issue, and that is whether the Act is constitutional or not, and they'll share that both Justice Mungare and Justice Chigiti.
Having disposed of the technical points, we now turn our attention to the merits of the petition. The brief background is that by judgment of this court, differently constituted, various provisions of the Finance Act 2023 were declared unconstitutional. One of the nullified provisions was Section 84 of the Act, which sought to amend the Employment Act in the following terms. And I quote Section 84 of the said Act. The Employment Act 2007 is amended by inserting the following new sections immediately after Section 31A. Insertion of new section of number 11 of 2007, Affordable Housing Levy, that 1B, notwithstanding the provisions of Section 32A, B, C, and D of the Act, each employee and employer shall pay a monthly levy to be known as the Affordable Housing Levy. 2. The purpose of the Affordable Housing Levy shall be to provide funds for the development of affordable housing and associated social and physical infrastructure, as well as the provisions of affordable home financing to Kenyans. 3. The Affordable Housing Levy shall not be used for any other purpose other than development of affordable housing and associated social and physical infrastructure, as well as the provisions of the affordable home financing to Kenyans. 4. The monthly levy payable by the employer and the employee shall be A. 1.5% of the employee's gross monthly salary for the employee and 1.5% of the employee's monthly gross salary for the employer. In the judgment aforementioned, the court expressed the view that Section 84 proposed to introduce a new levy known as the Affordable Housing Levy without a proper statutory framework to govern the imposition and administration of the levy. Accordingly, the court held that the provision was in conflict with Article 210 of the Constitution. The provision was therefore declared unconstitutional. However, the court granted stay pending the enactment of a substantive legal framework. It accordingly ordered as follows: that the introduction of the housing levy through amendment of the Employment Act by Section 84 of the Finance Act 2023 lacks a comprehensive legal framework in violation of Articles 10, 201, 206, and 210 of the Constitution. The imposition of the housing levy against persons in formal employment with the exclusion of non-formal income earners to support the national housing policy is without justification, is unfair, discriminatory, irrational, and arbitrary, and in violation of Articles 27 and 201 of the Constitution. The fourth respondent proceeded with speed and published the Affordable Housing Bill, number 75, by Kenya Gazette Supplement number 236 of 4th December 2023. It was processed and passed on the 21st February. The bill was thereafter of 2024. The bill was thereafter forwarded to the Senate on 12th March 2024, and upon being passed was given presidential assent on the 19th of March 2024. Sections 4 and 5 of the Act became operational immediately by dint of Section 1A of the Act. It was on the same date that the President, the Chairman of the Board, the rest of the provisions were operationalized on 22nd March 2024 by a special issue of the Kenya Gazette Supplement number 70 of 21st March 2024 through Legal Gazette number 54. The court takes judicial notice pursuant to Section 85 of the Evidence Act that following the operationalization of the Affordable Housing Act, the respondents proceeded to implement the Act by Gazette Notice number 4350, 4351, and 4351 of 12 April, and Gazette number 4495 of 17th April 2024, where the CS Lands appointed members of the board. It was the operationalization of the Act that precedes
Mambo iko shwari, siku zile hapa hiyo.
Of course, what will go fast is this approach. Anataka apology. What the gist of your case? So you're not with us. How now?
Enhance your company's digital presence with WIS Tanzania's comprehensive packages, including email and WhatsApp services, coupled with announcements across their social media platforms and mobile apps.
Because of Canada happens here. But some good performers give space for us. We are the ones that make the application. Kindly. So there is no way you can justify I'm saying she will speak, but she's still at the country is doing the application. Oh, you're there. I know I was so here. Now, the question is, there is an application which says assuming I was not arguing the application, by the way, I'm not. I've no issue. I've done very just the right. Assuming I was not arguing. Who was the You are right. Yeah, but you are right. So she will be the first one to say before we start. No, I think she will go back. Yes, she will go back.
Good afternoon once more. Just a minute, please. So we wish to issue the following directions on how we are going to proceed. For good order and pursuant to Rule 17 of the Rutunga Rules, which empowers the court on its own motion to consolidate matters for expeditious disposal, the following petitions are hereby consolidated. Petition number E 365 of 2024, where petition E013 of 2024, E014 of 2024, E015 of 2024, Nairobi petition E565 of 2024 shall be the lead file. All filings henceforth shall be made in the lead file. Now, pursuant to that consolidation, the parties shall appear as follows.
Okay, so the new order of appearance with the parties will be as follows. HA, the Ngali Gachagua, will appear as the first petitioner. The second petitioner will be Thomas Kimotho Maingi. The third petitioner will be Honorable Jane Jerry Maina. The fourth will be Honorable David Munyi Mazenge. Fifth will be Peter Gichobi Kamoto. Sixth additional will be Grace Modoni Mwangi. Clement Muchiri Muriuki will be the sixth. And the seventh will be Edwin Monene Kariuki. The respondents will appear as follows. First, to the fifth respondents, as they appear in E565 of 2024, that is the Speaker of the National Assembly as the first respondent, National Assembly, Kenya the second, Speaker of the Senate will be the third, the Senate of Kenya will be the fourth, and the Honorable AG will be the fifth. H.E. William Ruto, the President of the Republic of Kenya, will appear as the sixth respondent. And the interested parties, the first interested party will be LSK as first interested party. That is the second one. The second one will be Professor Kithure Kindiki as the second interested party.
In the morning, in petition 3013 of 2024, I had not been notified, and therefore I learned from these proceedings in the national TV, and I decided to come. So therefore, yes, I came all the way from Kirinyaga, because Judge Richard Moore was very clear that we are going to be notified once the file is forwarded before the Chief Justice. There was no communication, so we were left stranded. What is happening, and our petition is being mentioned here today, and therefore we have had to rush very fast so that I can make it in the second session, afternoon session. Therefore, I wish. Yes, maybe perhaps we can.
Section E13 and E14, Kagwea.
Yes, it was consolidated, and we were told that we are going to be notified. However, we were not notified. I just learned of it today on the TV at 11. So we had to rush very fast from Kerugoya so that we can understand what is happening and perhaps clarification purposes.
Is there anybody who has been left out of the...
My Lord, with your permission,
yes.
Just to draw to the court's attention, there is an application lodged on behalf of an interested party in the name of United Democratic Alliance, which can be considered at an appropriate stage. Thank you very much.
Intended interested party or interested party?
It's an intended. He has not yet joined us as yet.
And my Lord, on the parties,
yes.
In this petition, I'm assuming it's one of those that you have mentioned, 528
of 2024.
No, it's not.
You have not mentioned that petition. And,
Oh, okay.
and on that score, let me say this, that in the morning session, there were parties who had mentioned different petitions which were not before us. I think we should be very clear that we can only deal with matters which are before us. Should there arise a need for us to mention any matter which is not before us and which has been placed before us, we shall make that communication. So I think we need to be very clear that our jurisdiction is prescribed to particular facts. Thank you very much.
My lords, your leadership, permit me to request that the E565, in which the Deputy President is a petition, and E015, in which the Deputy President is a first interested party. Let the record of this noble court show that we were not given an opportunity to be heard on the issue of consolidation. Let the record show the court has acted of its own volition in the normal practice, even under the rules, is to accord parties to state their views on a proposed consultation. This is the court's own volition. We were not asked to give. Thank you.
Your Lordship, we have had the orders that have been granted by the court, consolidating the matters and creating another lead file. And that creates the problem we were trying to address in the morning, Your Lordships. That now this bench has created 2 lead files. We have 6 files that are before you, Your Lordships, with the lead file being E522. Which files are not before you? We have now created another lead file, E565. Your Lordship, those are some of the issues you were trying to raise in the morning. That if those other files were before you, this confusion would not be rising.
Mr. Ndegwa, there's absolutely no confusion in these matters. Let us not give confusions where in terms of consolidation, we have cited the rule under which we have added Rule 17 for avoidance of doubt of the Mpunga rules. I think we need to move forward.
Yeah, and my lords, on behalf of the respondents, we confirm that we are ready to move forward. I think too much time has already been taken on issues that are not of any substance. So we would like to make 2 proposals. First, we would like, my lord, having read what has been filed by our colleagues this afternoon, we would like to propose that their application for recusal and this application questioning how the panel was put together should be had together for the very simple reason that they rely on the same set of arguments and facts. And I draw your attention to paragraph 5. They say that the impartiality of this court, the one we have before, has been questioned. And at the end of their prayers, they say that it is therefore in the interest of justice that this honorable court recuse itself. It would be gravely injurious to the respondents if they were allowed to prosecute this application, take one bite at attacking the court, and however the court rules, bring the other application for recusal and take a second bite. We would like to argue both of them together. Secondly, we would like an allocation of time, because it is quite clear to us that in the absence of directions allocating time, we are going to have another long afternoon of long, winded speeches that do not address the specific issues. We are willing to say in advance that whatever time you give us, if you give 10 minutes each, we shall accept. If you give 15 minutes each, we will accept.
Professor Gifu, which applications have been filed?
Yeah,
How many applications?
The one you directed, my lord, in the morning.
Yes.
But it is in that application that has been filed by Jindo Matiba and Company Advocates. That is the application that seeks, on the one hand, that questions how this bench was appointed, and on the second hand, it requires the recusal of this bench.
So for avoidance of doubt, it is one application.
It is one application.
There are three applications.
But there is an earlier application for recusal. And that's why I'm saying we probably can hear both of them together.
Yes.
I'm sorry, my lord, but my lordships and my lady, I just wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. And 159(2)b, justice shall not be delayed. So I'm requesting your lordships and my lady to kindly refer to that provision.
My lord, let it come on record that this is the first time in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, serve it, and come back to court. We have tried to do the best that we could in terms of complying with those directions. Of course, one of the issues that we could not be able to do is that the written application could not be able to do full justice to the instructions that we've been given and to our case. And therefore, my lord, when Professor Muigai stands here, counsel, to say that we need to be gagged on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, for purposes of the three, presenting the one other application.
Welcome to QNet's world of new beginnings, where every sunrise is a promise of our commitment to you, your health, your dreams, your planet, and your
deserve in an application of this nature. Secondary issue, my lord, is the issues of consolidation. Those issues of consolidation are as different as Uber can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusion. Because we've had to include. They are earlier complaint in the morning.
I'm sorry to say this.
I have.
Yes, I want to interject. If my learned friend is appealing against your order, get the right point. My lords and my ladies,
There is no, I'm responding to what has happened. Let us be fair to each other. And my lord, what I'm saying is this, that for purposes of those, that they will be sitting, the application under Article 165, because in the morning when we raise the issue orally, because even the questions that was
happened
raised,
on Saturday,
you are raising issues against the
I think I have a right
Justice.
to raise those issues.
She is a party now, and we have served her.
Just give we have time to.
I just wanted for good order, my lord.
Is that okay?
We do the application of the issues of the Constitution.
I am on
Constitutional violations regarding the empanelment of the We shall need the court's directions on that issue. And we've gone through the authorities within the short period that we were.
Has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Professor Muigai was a former Attorney General. I respect him. He was also my teacher. Professor for criminal law. But my lord, the point that I wish to make is that I am acting for specific clients today, and as the court, I should be in silence, he will respond. And I dedicated that we have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated. We could not put it earlier in an application. So if I may proceed, my lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would seek on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. My lord, under the 2010 constitutions, the constitutions provide for the Bill of Rights. My lord, under the former constitution, but under the former constitution, we used to have a practice in which we had an officially a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. But because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made on a Saturday. And my lord, we are also sitting here pursuant to an order made by the Honorable the Chief Justice. My lord, for purposes of Article 165, I believe it's 4, of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal applications. Issue number 2, my lords, arising from that.
You apply that we discharge the directions of empanelment.
My lord, I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. My lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that were made. My lord, I have a lot of respect for all of you that have appeared before previously. But my lord, pursuant to my instructions that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoyed special privileges. Number 2, my lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my lord, and it is important that this issue is speak for the 190 and with a clear conscience. 2 things. My lord, the first thing would be this, that if this matter is going to be conducted, like today, on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state? As it used to happen those days before we had a new constitution. Issue number 2, my lord, is this, the issue of bias. And this is bias by the Honorable...
I think, Mr. Mugai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you...
Let me raise the other issue that then does not have to do with those prayers. Well, the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my lord, there are about 4 matters, one of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this, for purposes of good order, and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see it, why I say this is important, is this. The matters before you over and over again the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So what, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application is clearly not permissible.
Mr.
So that, my Lord, I urge the court to hold.
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ is charged her administrative duties the way it should be done.
That is not administrative.
If you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that's right, as I said down, the issue of that right is that we have had a situation before the National Assembly, before the Senate, it didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
My Lord, sir, just to add on what my learned friend has submitted on, I will begin
with the permission of the presiding.
Yeah, we want the country to wake up and to revive and to give the life to the country. The country is Kenya, if you don't know what I'm talking about. Your Honor, let the lawyers say what they want to say. This should be part of the healing process of the whole country. Yes.
We have given directions on time allocation.
Your hands are not tied with respect.
Okay, tell us, just tell us, in your view, how much time do you want us to allocate parties?
What I'm saying to the tremendous respect, my Lord, we talk about time in civil matters and so on. But we are dealing here with the issue of impeachment. Issue of impeachment of the deputy president. It's not a small matter at all. It's a matter that is starting the whole nation. It has paralyzed the nation.
We have heard you, Dr.
And
Kalino.
let Paul Meter be given as much time as he wants. Let the professor be given as much time as he wants. Let the Honorable Attorney General be given as much time as he wants. That is the healing process. And from this court, we shall all march forward with confidence. If I may quote Mutajo Makinyata, kifua mbele na matako nyuma. Yeah. Okay. Let us do that. Let us forget about time. Where are we going? Where are we going with... Please, I'm speaking. Will you speak? Sit down. With respect, will you sit down, please? Khamino is talking. Will you sit down? It doesn't matter what you call yourself. Would you sit down, please? Yeah. I am talking. I have got the floor.
Under the rules of this court, senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down. I, as senior
I will
counsel-
not speak down. We're not practicing law. You are still doing breastfeeding.
That is not
Don't give yourself serious titles that you deserve at all. You are doing
Excuse me.
You are doing breastfeeding. Don't give yourself titles which you don't deserve. My Lord, what
Dr.
I'm saying to
Kabuna,
you.
finish what you are saying.
What
so
I'm
that-
saying to you, my Lord, we need a hearing process, and this court is going to provide that hearing process. Let the lawyers say what they want to say. What are we hiring for? Let us not have some people calling themselves professor or senior counsel, titles that don't mean anything at all when it comes to jurisprudence.
I think
yes. My
they,
Lord,
they mean something, Dr. Amina. They
What?
do mean something. Those
something means something when it is you and you approve it. Yeah. My Lord, all that I'm saying to you, let people talk. Let